Good morning. Resources for the Elderly program, and we are a co-funded project of the State Bar of New Mexico and the New Mexico Department on Aging and Long-Term Services. So we are excited that you are joining us live right now for this presentation on topics that come up often for senior citizens. So one of the things that I want to start with is a disclaimer, and that says this presentation is based on New Mexico law and is intended for informational purposes only. This presentation is not intended to provide advice, legal or otherwise. Because every individual's situation or problem is unique, there may be exceptions to the material presented that apply to your particular situation. You should always seek the advice of a qualified attorney for assistance with your individual concerns and questions. So I want to say thank you for all of you that are joining us right now. There are materials, I'm sharing my slides with you on the screen, and so you should be able to see those. But if you also want to do a printable or to download, this is a handout. In your GoToWebinar control panel, there is a box that says handouts, and there is a PDF of reference in the future, and I believe we'll be following up with that in an email too. So if you don't get it downloaded during this time, know that it will still likely be available to you. Okay. So there's also a box for questions in your GoToWebinar panel. And so if you have questions during the presentation, we would like to address those at the end. And so you can type them in as they occur to you in real time, and then we'll come back and revisit those once we're sort of have gone through most of the material. And that's just so that we have a good flow, but we want to be sure that you know that you can ask it when it comes up for you, so you don't have to continue to remember what your question was all the way until the end. So if you'd like to try that, feel free to go ahead and do a question in the box, and we'll go ahead and progress through the slides. So I'd like to first talk about the legal resources for the elderly program. And so we are a statewide program that is primarily a helpline and a referral service. We also teach these types of informational programs at senior centers, ordinarily during non-quarantine related restrictions at each senior center in each county in the state. And so the time frame when we get to those counties varies, but ordinarily we're able to go and meet with seniors in senior centers. But during this time, thankfully, we have technology that's allowing us to sort of meet with you this way. And so we're a helpline. If you have printed out your handout for today, I would just put a star by that statewide helpline number. It's 1-800-876-6657. And that's a great resource for you if you ever have a question that you would like to talk to an attorney about. As a senior, anybody over the age of 55, you can utilize that number as your first, your go-to, like your first touch with an attorney. And so you can call that number if you're over 55, and you can speak to one of the LREP attorneys at no cost. So that's an amazing resource that you can talk to somebody that knows about what you're going through and can kind of steer you in the right direction. So I would recommend that you put a star or write that number down and refer back to that at any time. I didn't mean to advance yet. Sometimes the attorneys on the helpline are not able to help draw up documents that you may need for your particular situation. And in that situation, the LREP is able to refer out to attorneys on the statewide referral network. And ordinarily there's a, on the state bar referral service, there's ordinarily a fee, but during this time, that fee is waived. And so you're gonna be able to be referred out for certain things like power of attorney or advanced healthcare directive, and be able to meet with an attorney in your area through that referral network too, if you're needing something kind of drawn up. So the common issues that LREP sees all the time for seniors are power of attorney questions, probate issues, and Medicaid issues. And so today we're only going to talk about the probate issues and Medicaid type issues. There are videos that are an excellent resource for you done by one of the LREP attorneys on powers of attorney for financial and healthcare. And so the healthcare power of attorney document is called an advanced healthcare directive. And for POA for power of attorney for finances, there are 2 videos. One is informational and one walks you through how to complete that document. And the same for the advanced healthcare directive. And so if you have questions about those videos are available to you on LREP's page of the State Bar website. And so I don't know if somebody in the one of the other organizers could put that maybe into the question link where that website page is, but that might be helpful too. And so if you have questions though, you can call the helpline, and they can also help direct you to those videos on the State Bar, on the LREP website. So today we're going to talk about probate and Medicaid. And so the first thing that I want to talk about is probate. And when I teach this seminar kind of live, I often run across so many questions about what probate is. And so there is a lot of confusion. We find that there's a lot of confusion about probate, and sometimes fear related to it, and just a lot of misinformation out there. And so even if you have never been involved in a probate situation, you likely have a neighbor or a friend who has been through something, and you may have heard their story. But we want to give you information today that will equip you to understand probate and to not be afraid of it. And so what is probate? That's the great question. And what it is it's a process about what happens to your property when you pass away. And so the sort of more legal definition of that is a legal process to transfer assets and pay debts after death. And so a personal representative is going to be a person that takes your estate through the probate process and through the probate courts. We also notice and hear that people often want to avoid probate, and so there are also ways to use non-probate transfers for your property if you want to handle those before you pass away, or to set in place mechanisms that will help you handle those and keep your stuff, your estate, out of the probate process. And so the big thing about probate is that it's going to say who gets your property when you pass, and who's in charge of that. Handle your stuff and where it goes. Then the way that you kind of tell the court what those preferences are is through a will. And so whether or not you need a will is a personal question, but this will inform you a little bit about who might need a will and what it does exactly. And so I've kind of already said that a will is a document that says who gets your property when you pass. And so you can give away property through a will, and you can identify exactly who gets what. You can also choose who is going to be the person that is your personal representative, the person that is going to be in charge of managing your stuff after you pass. And so with a will, it gets submitted to a probate court, and the judge is going to look at it and say, this is a valid will here, or it's not. And if it's a valid will, they're going to say, we're gonna let the personal representative named here do what the will says, transfer the property in the way that the will says. And so that is a really important thing to understand, is that a will does not avoid probate. A will tells the probate court and your beneficiaries and your personal representative, the person in charge, what you wanted to happen, and then it facilitates that happening. So you may pass away that you get a will done, or before a will, without no will, that's called passing intestate. And so the state of New Mexico knows that there are going to be people who have not taken care of making a will. And because of that, they put statutes in place, laws that will say what happens with your stuff when you didn't tell us what you wanted to happen with your stuff. And we just, those laws basically do what they assume they have put into place what they assume you would want to do with your property. And so the laws are going to think that you're going to want to give your stuff to your closest people. And the law assumes that your closest people are going to be your spouse, children, and so forth, up and down your family tree, until we find whoever your closest people might be. It also is going to say we need to put somebody in charge. And so the law says who we think you would have chosen if you would have done a will. And so if you did not do the will, the statutes, the intestate statutes for passing without a will are going to say, she didn't say who she wanted to be in charge, but we assume that she would want these people. And it's, again, it goes kind of up and down in your family relationships. And then it's going to say, this is who has priority to serve as your decision maker, as your personal representative, the person who manages everything going through. And the court is going to name that person and give them authority to act on your behalf after your passing. And so whether you pass away with a will or whether you pass away without a will, there's a really strong possibility that your stuff is going to get into the probate system, into the probate court system, and somebody's going to have to pass stuff out to your people, and the person that is tasked with doing that is called the personal representative. And so if you did not make a will, but you really want to avoid probate, or even if you did make a will, but you still kind of want to try to avoid probate, you don't want your family to have to go through that, you can use other documentation to facilitate non-probate transfers. And so these are things that do avoid probate, that you have said, this is who I want to get this particular stuff. And so non-probate transfers, there's a lot. We have a lot of these tools that we can use in New Mexico to facilitate transfer of property of the stuff that you own without a will, or without going through the probate process. And so some of these that you might be familiar with are joint tenancy. And so I sometimes say, if you own a house with a spouse, you probably own it in joint tenancy. Same with a bank account. If it's Mr. and Mrs. so-and-so, then that is probably a joint tenancy account. And that passes to the survivor outside of the probate process. There are also deeds in New Mexico that transfer real property outside of the probate process. And those are called transfer on death deeds. There are, in addition to joint tenancy bank accounts, you may have a payable on death bank account. And so a POD account is payable on death, and you name the beneficiary. And so if I have an account right now that I own just by myself, but it's POD to my brother, then that's his money when I pass away, and my husband misses out on that. And so that's one way that you can transfer bank accounts is POD, name a beneficiary that way. There are also transfer on death accounts, so TOD. These are things like stock and other types of investment accounts where you have named a beneficiary. Somebody made you fill out a form that says, when I die, I want this to transfer to so-and-so, to my best friend, or to my husband, or to my sister. And so if you fill out a TOD on an account, a TOD will also transfer outside of the probate process. So other times that you, other types of things that you may own that you've named beneficiary, a beneficiary on, such as an insurance or an annuity, some types of retirement accounts, all of those, when you've named a beneficiary, they pass outside of the probate process. It goes right to the beneficiary with just a little bit of whatever documentation that financial institution or that insurance agency needs. And so all of that sort of, anytime you name a beneficiary, you are avoiding probate generally. And so the last sort of non-probate transfer that people hear about and that I noticed that there's a lot of confusion about is trusts. And so sometimes people will come and say, I think I need a trust because I want to avoid probate, and that may or may not be a good decision based on their circumstances. But trusts generally do avoid what's in a trust avoids probate. And that's sort of a more complicated situation than we want to delve into in this webinar. And so that's a reason to call the helpline and maybe get a referral out. So just know that all of these are ways that if you want to avoid probate for whatever reason, you can use these to facilitate that. There's always the situation where you may have something that you forget. And so if you have a strong opinion about what happens to it, or you want to do something outside of what the statutes assumed you would do, then for sure you're going to need a will to be able to manage that after you pass. And so these are really specific questions and situations that people come into, but knowing that you have these tools, wills and non-probate transfers to manage your stuff after you pass, that you should be able to manage those things in a way that you want to. And so just remember that there's stuff in a probate estate on one side, and there's stuff in a non-probate estate. And the probate estate stuff is going to be decided by what happens, what your will says. And then your non-probate stuff is where you've named a beneficiary, and it's going to pass in spite of what you did over here on a will. So I would like to talk a little bit about joint tenancy, just because it's something that is a common way to own stuff. And so I said earlier, joint tenancy is often like if you own a house with a spouse, you probably own it in joint tenancy. And that's great. We love it when spouses own things together. It makes it simple when the first spouse passes. But sometimes people will come to us or call the helpline and they will say, hey, my spouse is gone. I'm a single woman now, and I want to add my kids to my stuff because I want to add them to my house deed. I want to add them to my banking account, and so they call with that question on whether or not that's a good idea. Sometimes their kids think that it might be a good idea. But at LREP, we do not recommend it. There are a few reasons. One, it gives your child or whoever you named that's not your spouse joint ownership over that asset. And so that might not be a good thing. It also lets their creditors potentially have access to that asset. And if you're of an age when Medicaid might be something that you need in the near future, such transfers, these adding someone's name to an account or a deed may make you ineligible for Medicaid. And so there is a story that the attorneys on the helpline often tell, where a woman called the helpline. She was an elderly lady, and she said, I'm in a little situation with my niece. And so a few years prior, she had called her niece. She said, I'm getting up in age. You're living alone in Florida. I'm living alone in Albuquerque. Maybe it would be a good idea if you came out here to Albuquerque and helped me until I pass. And in exchange for your time and your services and helping me as I'm old, I will give you my house. And then you'll be set up to continue in your life. And so the niece at the time, this is a few years before the lady calls the helpline, the niece thought, yeah, that's a great idea. I could use a fresh start. And so she moved out to Albuquerque and started living with her aunt, and realized a little bit later, maybe a month or two later, that actually she missed the beach. She didn't really want to live in Albuquerque and help an older lady. And so she was just going to move back home. And so she took off. She went back to Florida, and her aunt heard nothing from her. And so a couple years had passed, and her aunt had tried to get a loan out to make some handicap modifications to her home. And so the bank had said, we're sorry, until your niece signs off on the loan, because your niece is a joint owner on your house, we won't approve it. And so the aunt had called the helpline at that time and said, what do I do? And that is a situation where owning property with a non-spouse ended up as a very bad idea, because aunt was sort of stuck. And so we tell that story as a word of warning to anybody that will listen, really, that we don't recommend that you own property with a non-spouse when you could own it on your own entirely, and then you don't have anyone else making decisions about what you do with that property. A tool that would have been good for aunt in that situation, potentially before niece ever moved and backed out on her deal, would have been for aunt to utilize what's called a transfer on death deed. And so here in New Mexico, we have this wonderful deed option that the owner of property can say, I want to own my real property here right now. I want to own it completely, as I have always owned it. But when I pass, I know I want to give it to my niece. And so this transfer on death deed allows someone to own it while they're alive and to transfer it outside of the probate process when they pass. And so it's a very cool tool to utilize for planning in the right situations. So the good things about it are that the owner keeps full title and control while the owner is alive. So if you own it and you record a transfer on death deed, you can still go and sell the property or get a loan or whatever you want to do with it. Lease it out. You can do anything that you could normally do with it because you fully own it. You have to sign the deed and record it while you are alive. And so those two pieces are really important to have it a valid transfer on death deed. No title transfers until you pass. And so it's recorded, it's sitting at your county clerk's office in the recording department. Not the physical deed, but the record of it. And when you pass, that person who's the beneficiary of this transfer on death deed takes a death certificate down, and they fully own the property at that point. Things that are also good about it are that you can revoke it, you can change your mind, and you can do a new one if you want to. And so with the story of the woman that called the Helpline, her situation, if she had done a transfer on death deed to her niece, when her niece took off and went back to Florida, she would have been able to revoke her transfer on death deed and sign a new one for whoever she thought that the property should actually go to. And the last point on the slide is that you can sell the property or borrow money on it. And so again, you have full ownership of it, just like you did. It's recorded, it's waiting. If you change your mind, you can do a new one. But this is a great tool for certain situations that you might want to utilize. A couple other points on the transfer on death deed are that a beneficiary cannot take property or borrow money on it until the owner passes. And so that beneficiary has no legal ownership over the property until the original owner dies. And so the beneficiary cannot do anything with it. They can't lease it out. They can't say, I'm going to borrow money. And so they keep the original owner out of trouble on it because they're not involved until the owner passes. And that's when their interest vests. This property, again, it's outside of the probate process. So it transfers without having to go and get the will, get a judge to look at your will and do all of that. And so that's a nice thing too. It's a faster process. It does not affect your Medicaid eligibility because there's no transfer of interest until you're gone. So that's a good thing to know. A caveat on all of transfer on death deed being a fantastic tool is that it's a fantastic tool for certain situations. If you're transferring to one other party, we say that it would not be advisable to do a transfer on death deed to your 4 kids. And we note that if your 4 kids can't even agree on where to go out to dinner on a Thursday night, they are probably going to have a difficult time figuring out what to do with your property when you pass. And so because of that, we recommend that you don't necessarily utilize this tool in that situation, and that you might talk to an attorney or call the helpline to figure out what would be a better idea for you in that sort of situation. So if you want to transfer to one other person, transfer on death deed might be an excellent tool. If you have a more complicated situation, again, you may want to talk to somebody about your situation and what's going to work best specifically for you. And so that kind of covers our probate and non-probate topic for today, which leads us to Medicaid. And so again, Medicaid is an area where I noticed that there is a lot of confusion and a lot of people have a lot of questions, and they may have heard like a scary story from their sister, their sister's best friend, and such and such, and it can be a scary thing. But we're here to just kind of give you some framework for understanding what Medicaid is and how to keep your eligibility sort of safe, so that you may, if you need it at some point, you may be able to get it. And so Medicaid is basically paying for long-term care. And so in this context of this webinar today, we are talking about about Medicaid in relation to nursing home stays and long-term care. And so there's an important thing that Medicaid is not the same as Medicare. Medicare is insurance that you paid for through Social Security. Once you turn 65, or if you are disabled, you may qualify to have Medicare as your health insurance. It covers, in the nursing home context, it covers short-term skilled care. So if I break my hip and I go to the nursing home for 2 months for rehab, then that may be something that Medicare can pay for me. In that it's skilled, it's physical therapy type, rehabilitative type therapy in the nursing home. Medicaid, on the other hand, is a government benefit for people who cannot pay for their care. So it's not insurance, it's a government benefit. And in the nursing home context, we're talking about care that is related to your daily living, what they call custodial care. And so this is when you're having a hard time, when a person is having a hard time getting dressed, bathing, feeding themselves. And so if they need to go to the nursing home, not to rehab from surgery, but they go to the nursing home to kind of live their normal everyday sort of life, that they need custodial care in the nursing home. And the way that they can have that paid for if they can't private pay is through Medicaid. There is an income and assets test that Medicaid has to figure out if you qualify for Medicaid as a government benefit. So the income test, get my screen on the right page. So the income test, Medicaid says that you cannot make more than $2,349 a month in income to qualify. They're gonna let you, if you're going into the nursing home, they're gonna say you can keep $74 of your income every month for your personal needs to buy Twizzlers and the lotion that you like or whatever it is. And the rest of your income is gonna go towards paying for your care in the nursing home. And so that feels like if you have $2,000 a month in income and you have to only keep $74, it may feel like, wow, they are taking a lot of my income each month to pay for my nursing home care. And the reason is that they are going to be picking up a big portion of the bill. In New Mexico, our average cost to spend a month in the nursing home is almost $7,500. And so if you're keeping $74 of $2,000, $1,900 from you is going towards your nursing home bill for your day-to-day custodial care. But your bill is actually $7,500, and so Medicaid's going to be kicking in, you know, I'm not a math person, but like $5,000 of your bill each bill of $5,500 or $5,600 or something of your bill, so that you can continue to live in the nursing home. And so it's very possible that you may not make something that you can pay $7,500 on your own, but you make more than $2,300 a month. And so if that's the case, if you're sort of in the gap there, then you certainly need to call and get advice. So start with the helpline, call the helpline, and figure out what attorneys you may need to talk to figure out how you can qualify if you're looking at needing to go into the nursing home for custodial care. So that was the income test. There's also an assets test. And so they want to know what else you have. And so they're going to let you keep $2,000 in a non-interest bearing account if you're to qualify. You can also have $1,500 prepaid to like a funeral home on a burial or funeral home or some sort of burial type account. They're going to let you have a car of any value. And they're going to let you keep a home with almost $600,000 in equity, $595 in equity. And so there's an important point to that, which is why I just want to get help if you're trying to qualify, is that you have to say, you know what, if I can all of a sudden start going home and taking care of myself there, I want to go home. And so you be able to check that box on the Medicaid eligibility form so that they know that you want to keep your home because you might want to be able to go home if you can. And so they're going to say you can keep your home in that situation. If you own that home that's worth almost $600,000 and you live in the nursing home for a long time when Medicaid was paying the most of your bill, it's possible that they could come back with a claim against your estate. And so it's hard to say if they will or they won't, but just know that it's a possibility. And so that you can prepare your kids or your other family members that there may be a claim after you're gone, just kind of depending on how your nursing home situation, how long you were there, what it costs, and all of that. So if you are needing Medicaid and you're a married person, if only one of you is going to the nursing home, so if I'm sending my husband into the nursing home to live because he needs custodial care, then I'm going to be the at-home spouse, and Medicaid's going to say the test is a little different. They're going to let me keep half of our income because they know that I'm going to have house bills too. He has his bills at the nursing home, but I have my bills too at our home. So they're going to let me keep half of our income. They're also going to let me keep a house of any value. So I'm not going to have to move even if I have a $1 million house. They're going to let me keep one car of any value, so I can continue to drive the car that I want to drive, and Medicaid's going to be okay with that for him to still be going and qualifying for the nursing home care. And they're also going to let me keep some other assets, and so there is a minimum and a maximum on that. But if you have questions, this is a reason to kind of call the helpline. Now, if me and my husband are going into the nursing home together for day-to-day life care because we really need help with all of it, they're going to treat us both as single people. So he's going to get $74 that he can keep, and I'm going to get $74 that I can keep. And the rest of all of our income is going to go towards paying each of our bills. So know that if we're both going in together. It's a little different if somebody's staying home, but if we're both going in together, it's going to be like we are both single people. And so let's talk about things that may cause an issue for qualifying. Medicaid has what they call a 5-year look back period. And so they're going to look back at what you've done in the last 5 years before you're trying to go in for that custodial day-to-day life care. If you have transferred assets, if you've added people's names to bank accounts or to deeds or given away your home, all of that is going to look like it may disqualify you for a period of time. So if you transfer a $100,000 home to your child and then you need nursing home care, Medicaid may say, hey, that was a $100,000 home. That was $100,000 you could have used to pay for your care, and so we're going to make you pay for a while before we kick in, because that was money you could have used to pay for your care. So know that. And if you're thinking about transferring assets and you're anywhere close to thinking that you might be in a Medicaid, nearing a Medicaid custodial care kind of age and need, you should talk to somebody before you do any transfers. Things that Medicaid considers transfers, which I've sort of said, are putting someone's name on an account or a deed. They're going to say that's a transfer. They don't consider it a transfer, no penalty for a transfer between spouses. And so they sort of promote marital harmony in that sense, is that it's okay to give stuff to your spouse. But kids are a totally different situation. Sometimes you may have too much in assets, and so before you can qualify, and so you may need to spend some of it down. And if you do need to do that to be able to qualify, then you're certainly going to want to get advice in that situation. But know that you may not be stuck. You can get some help. And so good time to call the helpline and talk to one of the attorneys there and get some good advice about going forward and qualifying. Okay, and so our last slide, which I just lost, is the questions slide. So I'm going to check the questions pod over here and see what's there. And then if you have other questions, you can absolutely submit them now. It looks like we have one. So if you use a transfer on death deed but sell the house, does it cancel the transfer on death deed automatically? Or does the beneficiary still have some right to any profit from the sale? No, if you sell a house with that had a transfer on death deed on it, it's like you canceled the transfer on death deed. And so it's specific to that property, and it is basically it's sort of like would function as a revocation. And so if you were buying something else and you wanted the same person to get it, you would need to record a new transfer on death deed specific to the new property. So hopefully that answered that for Jennifer. Any other questions? I can just sit and wait for just a second here while, in case you're typing in the chat pod. Okay, and I just want to remind you, so it's at the very first slide, is that the helpline, see if I can get there. The helpline is an excellent resource that we have here in New Mexico. And so if you're over 55, before you ever call an attorney, I would call the helpline attorneys because you can talk to them at no cost. And that number again, I should have it memorized, but it's 1-800-876-6657. So it was great spending a little bit of time with you all today. I hope that this was beneficial. And if you would like to share this webinar, it will be on the LREP page, and your friends and family can watch it too, because hopefully there was a lot of good information here, clarify some questions, and is helpful to all of you. So have a great day.